Hi, this is Brian Dolan with law firm Pepper Hamilton. Every month, Pepper partner Greg Nowak hosts a webinar for West LegalEdcenter on investment management issues. This month, Mr. Nowak will be joined by Pepper attorneys J. Dubow and Cassandre Juste. They will discuss the efforts of the SEC and CFTC during 2016. They will also look at what can funds and advisors expect in 2017. If you're interested in the PowerPoint slides they referenced during the webinar, please visit www.pepperlaw.com and visit our Insight Center.
Good afternoon. This is Greg Nowak from Pepper Hamilton, and welcome to this month's edition of our Investment Management Roundtable. Today I'm joined by two of my colleagues at Pepper Hamilton, J. Dubow, who's a partner in our white-collar and enforcement group, and Cassandre Juste, who's one of our new associates in the financial services group. And we will be going through some recent developments that we've had with the SEC, CFTC, Department of Justice, and others in the financial services space, particularly focused on investment management and funds. And I encourage you to ask your questions instead of waiting to the end. Please ask them along the way, and we will address them as they come up on the screen. So without further ado, let's get right into the materials. On Slide 2, you'll see that we plan on focusing on enforcement efforts and results by the SEC, various enforcement actions from the SEC and the Commodity Futures Trading Commission, the Department of Justice and SEC focus on individual wrongdoers, various whistleblower developments, and key practice recommendations for executive directors and chief compliance officers. So moving to slide number 3, the SEC has continued a trend that became evident a few years ago, and that is using technology and various new forms that have been required to be filed, the NSEN and the NPORT, to allow for efficient collection and analysis of data. This became evident when the SEC made its proposal last year to require the filing of suspicious activity reports. Actually, it was Treasury who made that proposal. But then they said that registered investment advisors would also have to file suspicious activity reports. 10 years ago, when the Treasury Department tried to do this, the hue and cry from investment managers was, these are all duplicative. Why you want to waste our time and money to do this? The response was at the time, you're right, we don't need them. This time around, those arguments have fallen on deaf ears. Why? Because they want as many data points as possible, and then they use their algorithms and electronic data slicing tools in order to find trends. And so the more data points you have, the more valid the trend line that you can draw. So the use of technology is now, we are seeing it, and we'll talk about it in some of the enforcement actions, how they were able to track down to the minute, within 5, 6, 8-minute intervals, various actions by alleged wrongdoers who ultimately agreed to settle out cases in, for example, an insider trading matter. We're also seeing increased use of the whistleblower program from the SEC, with now over $77 million awarded to whistleblowers during 2016. Expanded enforcement actions against investment advisors, investment companies, continuing a trend focusing on private equity. Now, again, many would ask, why are you focusing on private equity when there you have the archetypical institutional investors and high net worth individuals who presumably are capable of managing themselves? But from the SEC's point of view, the proof is in the pudding. They just need to see, every time they look at another fund, examples of what they believe to be egregious behavior where the investors have not been able to stop it through their negotiation and their ability to fend for themselves. And so we have seen a lot of enforcement actions from the SEC. Why? Because they seem to be relatively easy actions to bring. The facts are all egregious once they are brought to light by the SEC, and it seems as if the participants in those what were previously viewed as okay arrangements have been changing their tune. And finally, we have increased compliance focused on the whistleblower provisions under Dodd-Frank. Now, whether Dodd-Frank survives in its current form following the election and the change in Congress in January, who knows? We do think that there will probably be a skinnying down of some of the provisions, but a lot of the stuff makes sense. And so whether it survives in the form of Dodd-Frank or some other regulatory pronouncement, we shall see. Cassie, tell us a little bit about Slide 4 and some of the statistics that we've seen.
So for the 2016 fiscal year, the SEC has brought more actions than it has in the past 2 years, with 548 independent enforcement actions, 195 follow-on administrative proceedings, and 125 delinquent actions. And for the year, they have fined entities a total of over $4 billion in disgorgement and penalties ordered throughout the year.
Now, Jay, you used to be with SEC enforcement, and just sort of inside baseball here, when you have penalties and disgorgement ordered to this magnitude, is that actually collected?
No. A lot of times there will be orders for disgorgement and penalties, and the respondents or defendants don't have the ability to pay, or in some cases are recidivist or just won't pay it. But I mean, they do collect from from the sort of name brands, and from many of respondents and defendants, they do collect what the disgorgement and penalties order, but certainly not all.
But the impact of that, if they have an order against them, if they're also, for example, suspended, one of the requirements usually to be reinstated is that all outstanding penalties and disgorgement have been paid, right?
Correct. I think the types of entities or individuals that aren't paying their disgorgement or penalties aren't worrying about getting reinstated.
Okay. All right. So Slide 5, Jay, tell us about the various types of enforcement cases that we've seen in 2016.
Sure, Greg. This is just a sort of an overview of some of the cases we're going to be talking about, and is, I guess, the sort of the main message is that it's a real wide mix of cases. They look at lots of different things, and these are involving primarily some kind of registered entity investment advisor. So we have failures to supervise for insider trading violations, failures to adequately train employees to detect those. We also have cases involving whistleblower retaliation, cases involving failures to conduct annual compliance reviews and hiring a chief compliance officer with basically no relevant experience or little relevant experience. Cases involving improperly reclassifying assets under custody resulting in noncompliance with disclosures and misstating assets under management, cases involving FCPA violations, cases involving investment advisors acting as an unregistered broker-dealer, and of course, these are just a sample. There's many others involving investment advisors, and the SEC Enforcement Division is particularly active in this area, in large part because some of them are a result of examination. So, you have someone doing an examination from OC, and they see something that they think they should be talking to their big brother down the hall in enforcement, and they get them involved. And you also have whistleblowers and clients who complain as well.
So as was on the previous slide, you saw that there were 548 independent enforcement actions. Obviously, we're not going over all 548, but we did pick out a series of cases that we wanted to talk about, primarily because they have some unique facts, and they may, tell an interesting story of things to look out for, perhaps regulatory trends that we might see coming in 2017. The interesting thing is that no matter what we do or what we focus on, recognize it is just the tip of the iceberg, and the run-of-the-mill enforcement case may not make it into our list here. Jay, another quick question about procedural requirements with the SEC to bring enforcement actions. in order for an enforcement action to be brought, does not the Commission need to approve that enforcement action? And if it does, what does that mean with the announced resignations or retirements of various SEC commissioners that we've heard in the last couple of days?
So yes, in order to actually institute an enforcement action, that has to be approved by the Commission. When it's a full complement is 5 commissioners. Right now there are 3. There were 2. President Obama had nominated 2 people to fill the open spots. I don't think it's likely that those spots are going to be filled by those who President Obama nominated. And Chairman White has indicated that she's going to resign effective when the President changes over. So unclear about the other 2. And these are all terms. They're basically staggered terms. So when someone steps down, you get appointed to fill that 5-year, the rest, whatever remains of that 5-year staggered term.
So if Chairman White retires effective January 20th, which is what she said she wanted to do, then the SEC will be below quorum, and that means there will not be any enforcement actions brought?
There are under certain circumstances, there are ways that even with one commissioner, they can bring certain types of actions. So, enforcement, all the various divisions will continue working. The staff will continue working, and if there's any backlog, as soon as the appropriate commissioners are confirmed and seated, they'll be pretty busy if there's any backlog. And procedurally, the tradition is that there is always representation from each party on the commission. Yeah, it's required that there be at least 2 of not the party in office. So certainly you could have more, but you have to have at least 2 from in this case, obviously, it will be the Democrats. So they'll be, it will look to have 3 Republicans and 2 Democrats.
Okay, so without further ado, let's move to our first discussion case, a failure to supervise case. This is on slide 6 for those of you following along at home. Cassie, tell us about the facts. What happened in Artis Capital Management?
So Artis Capital Management is an investment advisor who advised various hedge funds, and they employed a research analyst that had previously worked at a networking technology company. This employee had a ton of tech industry connections, and when he advised the firm on what stocks to purchase or sell, the firm didn't require him to provide any documentation, no analysis of fund performance, anything of the sort, to kind of provide a basis for what he was relying on in making that recommendation. And the firm failed to conduct any investigation despite 2 really major red flags that the information that they were receiving from this analyst was material, non-public information. The first instance being when this particular analyst met with one of his connections and advised the firm to purchase stock of a particular company. They went forward in doing so. When days later a merger with that particular company was announced, they didn't do any further investigation or contact their COO.
So, and I think it's important to keep in context, outside of this civil matter, this administrative proceeding, the research analyst who was the malefactor here, he actually was sued for insider trading, right?
Yes.
In a criminal complaint. And he was sentenced to 5 years imprisonment in order to pay disgorgement of $900,000 in fines, prejudgment interest, and penalties, correct?
Yes, and the tipper that he received information from was also charged.
Okay, so the tipper was charged, the research analyst who actually got the information was charged. Jay, I thought under the Dirks case it was necessary to show that the tipper received some pecuniary benefit. Was that brought out, teased out in the underlying action here?
So yeah, in this action, there's no mention of what was what occurred in the underlying action that led to. But there was actually an SEC enforcement action and a criminal action. transaction. And so in that case, there was a guilty plea, so it didn't matter.
Guilty plea, yeah.
Exactly.
Okay, so let's then focus about this administrative proceeding. This is against the investment management firm itself that employed this analyst, and then his supervisor, a gentleman by the name of Michael Hardin. And just, flipping all the way to the end, there was a settlement of $8,800,000 against the firm in disgorgement, prejudgment interest, and civil penalties, and then the supervisor himself was suspended for 12 months and had to pay a civil fine of $130,000. So, again, not insignificant for an individual, consistent with what the SEC had said is they wanted to target individual wrongdoing as opposed to, having the firm pick up these expenses. But there was a couple of other interesting points here. One, the total client profit was $25 million, of which 8.8 of it, $5 million of it was actual profit received by Artist Capital Management with respect to its avoiding of losses and the fees it received from the trade. Well, that means there's $20 million that was profit derived by the clients of this firm, which are allegedly the fruits of wrongdoing, right?
Right.
So how do we reconcile that? I mean, we obviously have gone after the bad actors, and we've also gone after the firm, but what about the benefits that these other people derive, these ill-gotten gains?
Right. Well, I don't know if they're necessarily, I'd say, ill-gotten gains. I think you have to look at it. This was, a settled case. If you're the SEC, to basically be able to go in and grab the profits from those investors would be a tough call. Certainly, they had no knowledge of any of this. So the question then is, could you go after our artists or they're the only ones presumably would have funds that could make up that difference, that the individual who either tipped or the tippee in the first level certainly didn't have those kind of assets to go after and be responsible for. If they did, perhaps they would have required them to repay all of the downstream trading that came as a result of their activities. And we've seen that in other insider trading cases where they can't necessarily bring a case against the downstream folks, but they do bring it and seek recoveries from the original sources. But here, this was negotiated. I think there's issues of proof that the SEC would necessarily have that they didn't want to deal with at the level of the fund as opposed to the individual trader.
Okay, so because it's a settlement and therefore was not teased out at a trial, it looks as if the participants in the fund were able to receive and maintain those benefits. But a couple other interesting things here. Again, this was a failure to supervise case, which means that there had to be a standard established as far as the supervisor is concerned, because obviously if he is, as the supervisor, going to be held to account, then he needs to know what he can and can't do. So in this particular case, and again from your trial experience, Jay, they were able to determine that the tipper met with the analyst, and then the analyst telephoned Hardin, and the two men, according to the summary, spoke for 8 minutes. And during that time, he testified under oath that he had received information from the tipper about the approximate day on which an acquisition would be announced and the approximate purchase price. So while they were on the phone, a previously established short position in the company's stock was closed out, and they actually put on a long position reflecting a positive view of the stock's future price movement. So what we have here, it sounds like, is a circumstantial case, a lot of circumstantial evidence that someone probably did tip, right? But do we see a smoking gun here, or is the smoke enough?
Well, I think there's a lot of, again, you have guilty pleas, but you have a lot of smoke here. You have the timing is very suspicious. You have an individual who clearly talked to an insider, the insider had the knowledge of the events. And you actually hear, for purposes of the failure to supervise, if it was just one event, the original trade, you could perhaps, and again I say perhaps make an argument, that maybe he didn't have reason to suspect. But when it happens a second time and it's the opposite direction, and it turns out to be exactly right, then that raises a lot of red flags that you've got to do so. And I think that certainly was the nail in the coffin right there, that second one for sure. Again, I think the first one was very suspicious as well. But once you have that second one, it removes doubt.
Now, the interesting standard that was articulated here is that the employee's employment created unique risks because one of his primary job functions was to cultivate industry sources, some of whom had access to material non-public information. Despite this significant risk that the use of these sources could result in the company receiving material non-public information, the company had no written policy or procedure that reasonably ensured that the information that the analysts obtained from his contacts did not include material non-public information, or that such information would not be used for trading or tipping others. So that sort of puts the rabbit in the hat, right? Because you're saying I have a policy that I can't obtain or use material non-public information, but it doesn't say what material non-public information is. And more importantly, while I know the SEC takes a dim view of disparate information, the courts have always said that being in possession of disparate information, provided there was not a breach of a fiduciary duty underlying the receipt of that information, is not a violation of law, correct?
Correct.
So here we have a circumstance where someone had disparate information, but we had the guilty pleas underlying it that suggest that it was achieved in an inappropriate way.
Right. I think, here you have a guy whose job was to go out and talk to people in the industry, get information. There was nothing that was done. The SEC said they should have kept track who he was talking to. Did they have access to inside information or not? There's certainly information one can glean that's not material or non-public for that matter. But here, when it is both, that's a problem.
So let's set up a hypothetical here. Let's say that instead of keeping no notes, this research analyst does what most do in most firms. They keep a fairly detailed log of who they talk to, what they say, how they go about it. They also keep a fairly detailed Reg FD log for fair disclosure to make sure that if information is received, which they believe is a wink and a nod from an insider, they red circle that and don't use it. It's not part of their quote-unquote investment mosaic. So the mosaic theory is not dead, right?
Right.
And what we have here is someone who obviously was not keeping the notes, not building the case, and therefore couldn't defend himself when the regulator came a knocking.
Correct. I don't know if it couldn't defend himself or if it was that there was absolutely no defense, and that's why they didn't keep it.
Which is a very interesting point, and we don't know.
Right.
I mean, unfortunately, the record is not clear on that particular point. Okay, let's go to the next failure to supervise case, which is the UBS Financial Services, Inc. case. Cassie, why don't you lead us down the path here? What happened?
Sure. So UBS Financial Services provides wealth management services, and they had rolled out a new product that was single stock linked reverse convertible notes. It had a very complex nature. It contained embedded derivatives, and the SEC found that UBS failed to adequately train its registered representatives on the risk and the complexities of this product, which led them to make unsuitable recommendations to retail investors, essentially. A little over 5% of these RCNs were sold to retirees who had reported modest income and net worth and also had very little to no investing experience.
So offered to retail customers with the promise to enhance their yield and protect them from the downside, to give them downside protection, which, of course, we all know is the fool's errand of investment management. High yields with downside protection. It's very difficult to achieve. So Jay, what exactly happened here? We had a complex product. We had embedded derivatives in this complex product. We had a product that was attempting to smooth out implied volatility, and what happened?
Yeah, I think really what happened here, and you never know how these cases come about. Was this from an inspection, or was this from customer complaints, which could have been, or could the manager have raised a concern? But I think the bottom line here is you had retail customers who were, according to this, relatively unsophisticated and not of high net worth, who were investing in a complicated product that, from the description, not only did the investors not understand what they were investing in, but most of the registered representatives didn't know what their clients were investing in.
Right.
They weren't adequately trained. I think it's probably unwritten here. There's probably some nice fees for them for as well for investing, having their clients invest in these.
Well, and remember, this is a broker-dealer case, right? Where in broker-dealer world, we do have a much more stringent licensure process where all of your registered reps need licensure. There's a required firm element every year to make sure that people are up to snuff with their continuing education requirements. So there are a lot of opportunities and windows that are regimented in the broker-dealer world, which obviously they believed weren't met.
Right.
In the investment management space, you don't have that same degree of regimentation because there is no per se licensure like you have at the broker-dealers. And so a lot of it on the investment management side is left to best practices from policies and procedures, making sure that whatever you're doing, you're discharging your fiduciary duty. Now, remember, the fiduciary duty of a broker-dealer and a broker-dealer representative has always been defined as best execution, getting the best price for a proper amount of time for the client who wants to buy a particular security. The fiduciary duty for an investment advisor, however, is threefold. It's buy, it's sell, and it's hold. The decision or recommendation to hold a security or stay in a position is an investment recommendation. And so the investment advisor has a different fiduciary duty than that of the broker-dealer. What we're seeing, of course, after Dodd-Frank is the regulators attempting to push those two standards together and seeing how it's so difficult for that to happen. The Department of Labor, in its recent rules, also attempted to force broker-dealers to adopt a fiduciary standard acting in the best interest of the client. Not yet 100% effective, but it will be in place beginning next year. And so we're seeing the brokerage industry reacting by requiring special contracts, by throwing smaller clients out of actively managed accounts, and a whole sea change in the way broker-dealers are responding. Many of them hope that a change of administration is going to see a tempering of the Department of Labor proposal, but, let me pose a question. If you are in Congress and someone says to you, we need to repeal the DOL rule, and the other side says, wait a minute, if you want us to repeal the rule that says brokers have to act in the best interest of their clients, and replace it with what? That they could act in their own best interests? I mean, the moral opprobrium associated with the repeal of the standard, you could just see the headlines, right? So I don't think you'll see a repeal, but I do think you may see a sharpening, some exceptions, some new safe harbors, essentially ways for people to comply without feeling they're going to be out of compliance simply by doing what they normally do. But that's sort of the other side of the coin to these failure to supervise cases where you have a large firm like UBS being, tagged for failing to adequately train registered representatives with respect to complex securities. It could very well also have been just a convergence of a number of factors, the most important of which, complex securities, lack of training, and an unsophisticated client base with respect to these particular things.
Yeah, just one other point I think is worth noting from this case. So, again, it's settled. The violation, the primary violation here is it's Section 17A3, which is of the 33 Act, and it's a prohibiting engaging in a course of business that operates or would operate as a fraud or deceit upon the purchaser in the offer or sale of securities. But as noted in the order, and there's going to be a theme here today, 17A3 does not require scienter or a willful or extreme negligence standard. So it can be done through simple negligence, which by agreeing to this type of a charge does not put the firm into the bad boy provisions under, say, 506 that would require a waiver for them to make certain offerings.
Well, let's put a finer point on that. If someone consents to being determined to be a bad actor under 506, then they're out of the private placement business, right? And a firm like UBS would essentially kill the firm.
Right.
And as you said, there are exceptions, but don't those exceptions need to be approved by the commission?
Yes.
So goes back to our original lead-in. With only 3 commissioners, you have an overburdened commission and staff. With a changeover in administration, who knows how quickly they'll be back to full strength.
Right, but also, firms, banks, individuals for that, no one wants, if they can avoid having to agree to a charge that includes, they want to avoid a scienter-based fraud charge and take a it's much better to say there was negligence rather than willfulness.
Yeah, one of our presidential candidates tried to play that card. Okay. Let's talk about the next case, which is the International Game Technology case. It's a whistleblower retaliation case. Cassie, what happened here?
So International Game Technology, which is a publicly traded company, had fired one of its employees after this employee raised concerns that there were a potential misstatement in the financial statements. Now, this employee was the director of a division. He had received excellent performance reviews up until raising these concerns. He had received one of the highest bonuses in the one of the highest bonuses in the company. So he has a track record for being a very good employee. When he realized that there may have been this discrepancy with the financial statements, he reported it to his immediate supervisors and then eventually put in a complaint to the company's internal hotline and the SEC. The company conducted an internal investigation that found that there was no misstatement in the financial statements. I think he had estimated that discrepancy to be about $10 million. And they did not find any discrepancies there, and he was fired on the same day that that investigation came to an end.
So here we have an alleged whistleblower who says he found a mistake or an issue, and that these inaccuracies were persistent and had persisted for a number of years and that they were material. But their internal investigation, from what you just said, found that there were no mistakes.
Right.
And he was fired on the day that they said that there were no mistakes.
Right.
So Jay, what's the basis for a whistleblower suit if in fact internal investigation shows that there was no issue?
Right. So, the basis here is that he was fired. Also, he was prior to that. There was a change of status. A couple things that the SEC staff noted in this release that they viewed as retaliatory. And the standard for protection, though, is if someone has a good faith belief that there was some wrongdoing, it doesn't have to actually turn out there was actual wrongdoing. What this action is merely, again, against the company, and there's a settlement here. The SEC action isn't any kind of recovery for the employee. I would presume the employee most likely brought a separate action
for
wrongful termination, either through the Department of Labor. OSHA, I think, oversees those actions, and or there could have been a separate complaint brought as well.
But there were two things that were alleged here. One, that he had been removed from an corporate integration project, which apparently was a plum assignment. And then secondly, he had been precluded from attending a global gaming industry convention where major vendors and suppliers would have been, and he had attended this conference in previous years. And as a result, he was precluded from meeting with those representatives to evaluate new products and to review existing relationships. And then he was terminated. So the question is, had he not been terminated, would those other two instances be sufficient examples of discharging, demoting, suspending, threatening, harassing, directly or indirectly, or in any manner discriminating against a whistleblower, which is the standard under Section 21 FH?
And the answer, again, these are very fact-specific, and it's unclear whether just alone without the firing, but there is some history here. So in 2014, there was a case actually involving a hedge fund, Paradigm Capital, where there was a trader who was a whistleblower, reported wrongdoing, and they didn't fire that trader, but they took away the trading responsibilities and put that person in a different area. No change in compensation. They stripped the person of their title, and eventually that person resigned. That was viewed as retaliatory, though. So you don't have to fire someone for it to be retaliatory.
Yeah, but it's interesting. Would saying you can't go to a conference, does the principle of double effect come in here? We don't have the money this year, so you're not going to the conference. Is that enough?
Just the conference by itself is probably not going to be enough. But in this case, there were other things as well.
Yeah. Okay. Let's move on to our next case, which is misstatement of assets under management. Cassie, what happened with Credit Suisse?
So Credit Suisse is regulated under the rules of FINMA, a Swiss regulator, and under FINMA rules, banks can establish their own criteria for disclosing net new assets and their AUM. Credit Suisse had a policy that would recognize a change in assets under custody to assets under management based on the client's intent to make that change.
So hold on a second. We're talking about a very large international institution regulated by a different regulator,
right.
The Swiss regulatory authorities, not the U.S., and they reclassify various client assets that they had in custody from a custodian arrangement into an asset management arrangement.
Correct.
Okay, I just want to make sure we have the facts. All right, so what happened? They reclassify this, and now we have the SEC step in after the fact. What happens now?
So essentially, the issue with the reclassification was that their own disclosures would require them to reclassify assets when the client kind of makes clear their intent to have Credit Suisse manage these assets. Some of the relationship managers, supervisors, were pressuring managers to reclassify assets when there was no basis based on the client's intent to do so, or not enough basis. There was not enough clarity that the clients were intending to have these assets actively managed by Credit Suisse. So the SEC found that the sole purpose for doing that was to meet targets, and that violated anti-fraud reporting and books and records provisions to the tune of $90 million.
And just, if I could add, the reclassification from assets under custody to assets under management was one of two ways in which the bank would recognize net new assets, and that was the critical item that increased, according to the SEC, improperly.
And net new assets for what purpose? Was it to show strength of the organization? Was it to trigger a bonus pool? Why would a large institution like this take these steps and keep fairly detailed records on reclassifications of these client accounts to go into the category of net new assets?
Well, the targets were for disclosure and with regard to how the bank was doing. It's certainly a sign in the private wealth business of increasing net new assets. There were targets that were set, and the only way they were able to meet, in many cases, these targets was through these reclassifications.
So basically what we had is they had a self-imposed standard on what was and was not considered to be an asset under management, and they were reclassifying inconsistent with that standard. Now, that probably wouldn't have been an issue, but the problem was the standard was disclosed. And then what we're talking about is the net new asset disclosures were then misleading because they were inconsistent with the disclosure. So this, goes back to the old saw that the penalty, the cover-up usually results in a greater penalty than the predicate problem, right? So had they simply reported consistent with their disclosures, this is how we classify assets, there would have been no issue. Or in the alternative, they could have changed their internal policies, right? And how they disclose.
Right. There was still a question of whether, I think, the way that if you read the order, it was unclear in certain circumstances where a customer's intent really had changed, and therefore whether an asset should have been treated just still merely under custody at the bank as opposed to being managed by the bank.
So once again, we're talking about Section 17A2 of the Securities Act and a $90 million fine. Do you think there may have been some horse trading here?
Well, again, 17A2 and 3, both of which are negligent fraud actions under the Securities Act, as opposed to 17A1, which would require scienter. There's a books and records provision as well, and it is a very high penalty, civil money penalty of $90 million. And that's many times that's part of in a settlement. You want to emphasize, it's really important not to have a scienter-based order, and so many times, again, I wasn't privy to any of this, so I don't know, but many times a penalty can be negotiated higher in order to avoid a scienter-based penalty.
Okay. Next slide. Dupree Financial Services, the failure to conduct annual compliance reviews. Cassie, what happened here?
So Dupree Financial Services is a registered investment advisor. They had consultants come in and create a comprehensive compliance policy. This policy required that the CCO would conduct and document a review of their compliance policies annually consistent with their obligations under the Advisors Act. From the time that Dupree became a registered investment advisor, they never conducted any compliance reviews. They appointed a CCO who was previously an administrative assistant with the firm, and after she was appointed, she continued in her administrative role and dedicated most of her time.
Just let's repeat what you just said.
Sure.
We had an administrative assistant, a secretary, who was appointed as the chief compliance officer. Now, we're not talking about someone who got a foot in the door and then grew into the job. This person continued with their administrative duties following this tack-on of the title.
Correct. And the SEC focused on the fact that she had no experience in compliance or in the requirements of the Advisors Act.
So, once again, the practice of some firms who thought that the CCO was one of those burdens and that they could ignore it became a real issue for them. If there is any message to take away from Dupree, it is that the Chief Compliance Officer function is a serious duty and function. It should be held by someone who knows what they're doing, who understands the rules, who has a budget, who can get the training that they need, because if they don't, the SEC will look at that person and when they ask the question, well, what did you do about X? The absolute worst thing that the Chief Compliance Officer can say is, I don't know anything about that. Because now they start to ask, well, what about Y? What is Y? I have no idea what you're talking about. And now all of a sudden the SEC smells blood in the water, and they know that they're dealing with an inexperienced person, and that person will end up with the firm being hung out to dry. So just, accepting an appointment, you need to say, am I ready for this? Do I have the capacity? As I always tell our young associates who, get spirited off by clients to undertake new duties, before you do that, make sure that you're in a position to be able to say no. Because if you can't, because you don't know or you need the job, then you shouldn't be a chief compliance officer, because ultimately you will end up causing yourself and your firm significant heartache. So Dupree Financial ended up paying a $25,000 fee, or fine rather, because their compliance manual essentially was still shrink-wrapped, was not right-sized to the firm, and we had an inexperienced chief compliance officer appointed. One of the important things that we always tell people is your compliance calendar, your compliance manual is a snapshot in time. And your firm and your people change. And new products are issued and new ways of managing money come to the fore. If your compliance manual is designed and you put it on the shelf, even if you refer to it, if it has not been updated to match the enterprise risk in your firm, then you have not been doing a good job on compliance. And that chief compliance officer should not only just be annually checking a list, they should also be asking the CEO, the salesman, what's happening in the field? How does this work? Do we need to make changes? Are there issues that you're seeing? And then you have to deal with them in an appropriate way inside the firm. Okay. Now we're going to talk a little bit about the Foreign Corrupt Practices Act. And this is the FCPA from the point of view of the SEC and how the SEC focuses here. For those of you who are regular attendees at our program, the December session is going to have a deeper dive into the Foreign Corrupt Practices Act from the point of view of the Department of Justice with my partner, Martin Bloor. So we hope to see you for that program. But, Cassie, what happened in VimpelCom?
VimpelCom is a publicly traded telecommunications provider. The company paid over $114 million in bribes to the Uzbekistan government for the purpose of obtaining government-issued licenses, number blocks, frequency channels, and things of that nature. And most of these payments were funneled through an entity affiliated with Uzbek officials through sham contracts. And then they had about $500,000 that was disguised as charitable donations. So that resulted in over a $167 million fine to the SEC and almost $800 million in total.
So 167 to the SEC, 230 to Justice, and then roughly $400 million to the Dutch regulators. Jay, how does the concurrent jurisdiction between the SEC and Justice work here? I mean, I'm assuming the SEC had a disclosure violation that they were pursuing.
Yeah, I mean, these work. They work together, and they, not only in this area, certainly in other areas as well. More and more these days than even historically. But in the FCPA area in particular, it's more often the case than not that if there's an FCPA violation, you're going to have to address both the SEC and the Department of Justice in trying to get it resolved. And typically, these FCPA cases most of the time involve an internal investigation that's brought, that the company does to try to find, what's going on. You get either someone learns through a whistleblower internally, or even sometimes the government contacts the company and raises they've gotten some concern. They may allow the company to do an internal investigation, and many times the auditors might find some issues of concern. I've done a few of these internal investigations, and you have to be able to do them quickly, as quick as you can, because you're often holding up the filing of financial statements while those investigations are pending. And so you have to dig deep, and then as you uncover these, then you're reaching out to both the SEC and the Department of Justice to let them know that you're looking into this, and you'll share the information, when you learn, either as you learn that there's significant information or at the conclusion depending on how serious the nature of these are.
So in VimpelCom, the SEC alleged a violation of Section 30A of the Exchange Act, which is an anti-bribery statute, right? They also alleged a corporate books and records violation for, a number of instances where they failed to keep detailed records accurately disclosing the fact that these were bribes. And then third, they got the company on failure to have proper internal accounting controls.
Right.
So again, hypothetically speaking, had VimpelCom stated in its financial statements, we are paying a bribe to, the president of Uzbekistan, it presumably would have not been liable for the internal accounting control or the corporate books and records, but there still would have been the 30A violation.
Correct. Correct. And it's really the flip side. And the reason, those are part of the FCPA, the 13B2A and 13B2B, the books and records and internal accounting controls, because typically when you have any of these payments, they're not called bribes. They're usually called some kind of consulting services. And so you have the books and records right there and violation. And then, to allow such payments to have occurred, you've had a failure of proper internal accounting controls. So they usually go hand in hand.
They all go hand in hand. Okay, so Cassie, what happened in OXIF? Again, this is an FCPA case. We're going to do a much deeper dive in OXIF in December. But for our purposes today, what happened?
So it's pretty similar to what happened in VimpelCom. OXIF is a hedge fund, and its investment advisor settled with the SEC regarding use of fund intermediaries to pay bribes to high-level government officials in various countries in Africa, Republic of Congo, Libya, Niger, Chad, and a few other countries in Africa. And then the executives saw red flags and ignored them and allowed these transactions to move forward in spite of those red flags.
So here again, Jay, we have a $200 million civil fine and disgorgement and prejudgment interest. The CEO himself was required to pay a $2 million fine, but not Sientra-based.
Right.
So again, an interesting fact pattern there.
Yeah, I think if you look through it, there's a lot there. And I know you're going to look at it next month. I think there's certain of the respondents, not the management corp, and certainly not the individuals, but there's certain of the respondents, like OXIF management, which does have a 2061 provision that it's agreeing to in here, which is the Sientra-based provision.
Going to slide 13, Blackstreet Capital is a topic that we covered a few months ago. But basically, just to refresh everyone, Blackstreet was a manager, registered investment advisor, not a broker-dealer or a member of FINRA. It managed 4 different private equity funds. The managers of the RIA were not associated with the broker-dealer. No one had a Series 7 or 79 license. But the PPM and the LPA both disclosed that the RIA would take fees attributable to transactions. Basically, Blackstreet was required to disgorge a significant penalty and profit, and the SEC's position was, as set forth on slide 15, although the LPAs expressly permitted Blackstreet to charge transaction or brokerage fees, BCM has never been registered with the Commission as a broker, nor has it ever been affiliated with a registered broker. Rather than employing investment banks or broker-dealers to provide brokerage services with respect to the acquisition and disposition of portfolio companies, some of which involve the purchase or sale of securities, BCM performed these services in-house, including soliciting deals, identifying buyers or sellers, negotiated and structuring transactions, arranging financing, and executing transactions, and that they received at least $1.8 million in transaction-based compensation in connection with providing these brokerage services. SEC puts the rabbit in the hat, concludes that all of the activities identified here were in fact brokerage services, and then goes one step further and says, because the entity that received the transaction-based compensation was not a broker, that they had to disgorge the fees. When Blackstreet came out, it caused quite a stir, particularly in the private equity side of the house. The SEC's view is, what? What's the big commotion? This is settled law. We're not changing anything. But, in the eyes of the industry, it was a big change because, for years, this was sort of the crazy ant in the attic. Everybody knew it was there, but nobody paid any attention to it. And unfortunately now, Blackstreet is there. And what we're seeing is a lot of firms focusing on whether they should have a broker-dealer or whether their people should be licensed and affiliated with a broker-dealer. But recognize, once you have a broker-dealer in your corporate structure, the broker-dealer, by rule, will require it to be the center of attention. And it will require transactions to run through it, and it will require you to maintain certain amounts of net capital. While it clearly can be done, and it is done very well by many large firms that have broker-dealer affiliates, if you go down this road, you need to be certain that you're going to spend the time and the resources necessary to understand what you're doing. Broker-dealer operation is not for the faint of heart, I guess is the best way to describe it. Quickly flipping to slide 17 in three-red trading. Cassie, what happened there?
We have a Chicago-based futures trading company and its founder that was engaged in spoofing, which is an illegal practice under Dodd-Frank. They would place large orders on one side of the market to induce others to also place orders at a similar price point, and then they would cancel the orders before they were executed and flip their position, and then basically they were able to buy at prices and quantities that they wouldn't have been able to otherwise.
So this, Jay, would in another world have been considered conditioning the market or manipulating the market?
Yes.
And so just calling it spoofing doesn't mean it's better or legal.
It's just using technology.
It's just using technology. That's right. So, again, interesting hypothetical question here. Could spoofing be cured by a software change, which would essentially not allow firms who put in orders to cancel them right before they're exiting?
Well, no, yeah, I mean, it could, but I don't know if you necessarily want to require that. I mean, there are legitimate times when people put an order in and need to cancel them. It's certainly, and this case, there's an issue of proof here, so they have to actually prove what the intent was, and presumably, and this went before a grand jury, so presumably they had, because it's a higher standard, they had such proof. But, I could imagine there's somebody's type of a different case where it may be hard to prove what the intent was. Someone sometimes cancels orders, sometimes doesn't.
And that's what the founder was saying initially, was I place and cancel orders all the time.
Right. Yeah. But they found intent, right, to manipulate.
Right.
Jay, the Yates memo has been around now since 2015. It caused quite a stir when it came out. Will it continue to have legs, do you think, going forward?
Yeah, I mean, I think the Yates memo, frankly, I know some people thought it was caused a stir. I didn't find it much as a stir, maybe a little nudge or a little breeze. There's a history here. There's been these types of memos focusing on corporations since going back as far as 1999 with the then Deputy Attorney General Eric Holder. That was back in the Clinton administration. But then there were a lot of interim. There's a Thompson one in 2003, the McNulty memo 2006, the Fleet memo 2008, and culminating the Yates memo 2015. And it's just going after the Department of Justice and has to focus on individuals, not just entities. There was a concern, a big hue and cry from all the actions in these large institutions settled as a result of the financial crisis, and there's very few individuals who have been named, and so there's been a lot of criticism from Congress and others, which I think led to that. And we have seen it. I've seen it in my practice that the government is certainly much more focused on individuals these days, and you can't. It's much more difficult if you have an individual to try to get that individual off. I heard Yates' memo back to me a number of times from the government. What will happen in the future? I don't think it will necessarily be revoked, but it may some of the edges could be softened depending on who, how the Department of Justice goes forward and who's going to be heading it.
Well, if Senator Sessions is the one who's been nominated, correct, to be Attorney General, presumably a law and order candidate like that is not going to soften much.
You would presume. That's right. That's right.
Okay, so let's in the last minute that we have available, Jay, slide 22, key practice recommendations for executives, directors, and chief compliance officers.
Sure. So again, I mean, these are things you want to focus on your controls and procedures. It's important to maintain a dialogue with your outside auditors and retain lawyers and accountants for complicated questions. Asset valuation is one that comes to mind. If you have a chief compliance officer functions that are outsourced, make sure you review the business practices, make sure that they have enough authority to implement compliance programs and policies, make sure they have regular in-person communications with the firm, given access to documents and information. You also you want to make sure that you have the proper indemnification, including advancement of legal fees if you're a compliance officer, and covered by appropriate director and officer liability insurance.
Okay, well, thank you both for your insightful comments. Thank you to our audience for your attention, and we will see you in December. Have a great Thanksgiving, everyone, and thank you again.